One of the most important and potentially contentious issues to be settled in a divorce is after child custody, the division of property acquired during the marriage. And if you don't have children or your children are all grown, then it's likely that the most important and potentially contentious issue to be settled in a divorce is the division of property acquired during marriage. Utah law recognizes that both spouses contribute to the property acquired during the marriage, regardless of the income source that acquired it. The court can divide all marital property regardless of which spouse holds title to the property or where it is located. A lot of people ask me if an inheritance or gift from family that your spouse may receive during marriage is something to which you can make a claim in divorce or vice versa. Generally, gifts of money and money that you inherited, as well as property or money that is part of a lawsuit settlement, is considered the separate property of the spouse who receives it. About the only other exclusion from what is usually divided between the parties in divorce is anything that can be traced back to your separate property you held before marriage. Let me give you an example of what I'm talking about. Let's say that before you married you had money in a bank account. Then, after you were married, you took that money and you bought a car that was titled in your name or you and your spouse's name jointly. Either way. Another example, if you inherited money during marriage and you and your spouse used that money to make a down payment on the purchase of a house. In each of those cases, the money you used to purchase the car or house may be treated as separate property and awarded to you, or it may be treated as a gift to the marriage and divided equitably between you and your spouse. But believe it or not, although it's discouraged and generally only done when the court feels there is no other alternative, a court can divide and award your inheritance or legal settlement on any other kind of property you own separately and premaritally in a divorce as well. Again, however, that is rare. Utah is not a community property state. Its law requires what is known as an equitable division of marital property. Equitable means fair, which is not necessarily equal. If the parties agree as part of their divorce settlement how to divide their property, the judge reviews the agreement to be sure that it is fair. Deciding what is a fair distribution of property includes several factors. The initial presumption for division of marital property is that equal division is fair unless other factors rebut the presumption, such as how long the marriage has lasted, the age and health of the parties, their occupations, the amounts and sources of income, and related matters. For long-term marriages, equitable may mean a 50-50 split, or the court may decide it is fair to give one party more or less than 50% of the property. Property division cannot be reopened after the order is final except under limited circumstances, such as misrepresentation, fraud, or concealment. For short-term marriages, the court may put the people back into the economic position they had before marriage. In other words, he gets what was his at the beginning of the marriage, and she gets what was hers. Property owned by the spouses before the marriage or received by gift or inheritance during the marriage, as I've said, is usually not considered to be marital property. Generally, each party gets to keep their non-marital property unless that property has been combined with marital property or is used in such a way that it takes on the legal status of marital property. There are two kinds of property, two main kinds, that have to be divided and awarded in divorce actions: real property and personal property. Real property is land and anything permanently attached to it, such as a house or other buildings. If real property was purchased during the marriage, it will generally be considered marital property, even if only one spouse's name is on the deed. Real property acquired during the marriage can be sold and the money from the sale divided between the parties, but that's not required in a divorce. Other options the parties can agree on or that the court can order include one party keeping the property by buying out the other and giving him or her what he or she would have gotten if the property had been sold. The court may order the spouse who is awarded the real property to refinance the mortgage so that the other spouse is no longer liable on the mortgage. In other instances, the court can award 100% of the real property to one spouse and offset the value of the real property by awarding the other spouse a greater degree of personal property and assets so that the award of the value of all marital property overall is equalized. Now let's move on to personal property. Generally, personal property is property that can be moved and anything that isn't real property. This includes things like cars, furniture, kitchen utensils, your jewelry, clothes, and personal effects, tools, pets. If the property has a legal title, such as a car or a boat, and it was purchased during the marriage, it will generally be considered marital property, even if only one spouse's name is on the title. Retirement and pension plans may include defined benefit plans, defined contribution plans, things like a 401k, state and federal government retirement or pension plans, private employer benefits, and some military retirement benefits. Retirement and pension plans get divided in divorce too. They may be regulated by federal and state law and by plan policies, and as a general rule, anything paid into any type of retirement or pension plan by either party from the date of marriage to the date of divorce is marital property. But any funds you may have acquired or other benefits you may have accrued previous to marriage are generally considered your separate property and not divided in divorce, although they can be if the court feels it's equitable to do so. Utah courts can award a spouse all of his or her retirement benefits and award the other spouse to receive something else of equal value, such as equity in the home or cash or other property. Or if there is nothing of equal value to give to the other spouse, then the retirement benefits may have to be divided between spouses. If a retirement account is to be divided or transferred to the other spouse, then a special order separate from the divorce decree, called a qualified domestic relations order or quadro, must be signed by the judge. Once a quadro is signed by the judge and approved by the plan administrator will divide the account or pay the benefits according to the provisions of the quadro rather than the provisions of the pension plan. There are lots of ways we divide retirement plans in Utah, and sometimes we use things that are special court orders, as I mentioned, called qualified domestic relations orders, that allow us to divide the retirement plan in half, usually without any tax consequences or any tax penalties, which are normally associated with the division of a retirement plan. So make sure you talk to your lawyer about whether you need a qualified domestic relations order and whether that needs to be made a part of your agreement. Make sure you talk to a lawyer before you deal with dividing your retirement plan. It's a complicated asset. You don't want any piece of it to be overlooked, and you want to make sure it's divided properly. The distribution of property between divorcing spouses may be established by a valid prenuptial agreement, although you should know that in my personal opinion, prenuptial agreements are hard to enforce no matter how well drafted if the court doesn't want to enforce one. Under the Uniform Premarital Agreement Act, agreements made in contemplation of marriage become effective upon marriage. A valid premarital agreement can exert control by a contract between the parties as to the rights and obligations of each of the parties in any of the property of either or both of them, whenever and wherever acquired or located. The disposition of property upon separation and divorce, and the modification or elimination of spousal support, and any other matter that does not violate public policy or statute that impose criminal penalties. A premarital agreement can address issues of child support, child health, and medical care and insurance, but cannot be absolutely controlling of these things if a court deems the agreement as harming the best interest of the party's children. Property you acquire post-separation is still subject to division and award by the court because you acquired it during the marriage still. One factor that generally, and that means very, very rarely, does not go into determining the division of property is fault. Marital fault, marital misconduct, is generally not taken into account when property is divided. Property division is a no-fault kind of thing in most cases. If you're thinking about separating, or if you're in the process and headed to be planning for how you're going to deal with your property in divorce, I suggest that you now, before you lose access to records, start collecting the documents and things like financial statements, tax returns, mutual fund statements, bank statements, checking account statements, etc. Gather all of the financial records that you may have around the house. These are things you want to go ahead and keep in a safe place so that you have them when you need them, and you will need them. The last thing you want to do is overlook things or forget about things because you didn't have the records to substantiate their existence or history. If you have questions about property distribution, please read and review the other material we have here on the website. I'm Eric Johnson.